Hi everyone, my name is Daniel Chesmore. This is the second video of our multiple part series for constitutional law. We want to talk a little bit more about separation of powers first. So starting with a more in-depth review of the limitations on state regulatory and taxing power. We'll eventually transition to federal executive power before talking about removal again, more in depth than our previous video. And then we'll talk about different types of 14th Amendment due process clause challenges. And then in our next video, we'll talk more about the free speech rights, First Amendment, equal protection clause, and other sorts of state actions which might violate the Constitution. And then we'll talk a lot about free speech and the rules pertaining to free speech and protection of speech. So starting here, we'll start with limitations on state regulatory and taxing powers. We talked a little bit about this notion of preemption, and we'll talk more in depth about preemption for this video. So Article 6 is where we get the powers derived for preemption. As we talked about, there are two types. We'll start with, there's express preemption, and within express preemption, we have some sort of regulatory inquiry of intent. We've got here within that the structure of that intent and that intent of federal law. And we ask ourselves in our analysis if Congress legislated and whether or not state law within the scope of that federal action had some sort of preemption provision. We look at statutory construction tools which the courts will use within our analysis of preemption. If it's whether or not if it's stated in the act, we look at the explicit words of the act. We look at legislative history, which might also work as a double-edged sword. Within legislative history, we look at that prior legislation and bills of the same session, for example, or committee reports, or some sort of conference statements that are public record. And so within express preemption, again, ask if Congress legislated there, look to the structure of the rule, the intent of federal law, and look for the plain meaning, the plain dictionary meaning there. And you want to read this actual statute to look at the express words of the statute for us to make that interpretation. And within Article 6 preemption here, we have where Congress explicitly preempts state local matter or state local action, and states and local governments must actually yield to federal law. And we look at the express intent there. We look for express federal intent. We look for semantics of words. We look at the canons of construction. We look at modifiers, syntax, how it's written, and we read statute in light of other sections. And on a specified manner, for example, express intent by writing of that statute, writing into statute specifically saying states may not regulate certain activity. And within express preemption, again, Congress explicitly preempts state local matter and must yield to federal law. So that is our general express preemption. We talked about that in our previous video here. We talked about field and conflict, and so that is one example. So within express, we think about express preemption, but there's also this notion of implied preemption that we think about. Implied preemption is distinguished from what we just discussed on express preemption here. If they are not in conflict, state law is not preempted. We want to look for some sort of conflict there, and that's part of our analysis. Now, within there, we look to whether or not the state action or the law expressly authorize the state legislator, maybe perhaps to have power. And then we look to that state conflict with federal law. And that state conflict with federal law there is part of our analysis, but we'll talk about implied preemption, where if they are not in conflict, then state law is not preempted, as we stated. And we look to the physical impossibility of any sort of potential conflict through it's contingent when Congress is silent on the issue. And within conflict preemption, as we talked about, because we talked about conflict and we talked about field, Conflict preemption is where federal law preempts state law, and there's a conflict which makes compliance with both impossible. We see this a lot in certain 10th Amendment issues when it comes to regulation of plants. Within conflict preemption, the obstacle impediment is some sort of impediment to federal purposes within that conflict. So within conflict preemption. And so we look for a conflict or we look for some sort of field. That's how I like to remember it. And it can be either express preemption where it's expressly stated, or it could be implied. It really depends on the fact patterns. It could be within the text of federal law, or it could be implied through the laws of Congress, like such as to declare war. A state should not be able to declare war if there is a fact pattern in which a state, like the state of Alaska, decides to declare war on some foreign country, then obviously that would be implied, there would be an issue with implied preemption absent any express preemption which expressly says Alaska cannot declare war, because we know through the Constitution that there is the express power for Congress to be able to declare war. And so if a state were to try to take over that power, there would be this issue of conflict preemption. There would be a conflict. And if there is that conflict between the state and the federal government, federal law preempts state law on that conflict. And so, because that would make compliance with both impossible. And so that is a great example of implied preemption. But if there is no conflict, like let's say if Alaska decides to, a number of possibilities. If Alaska decides to regulate certain actions within its borders, such as if they regulate their state roads, for example, and there's an absence of any sort of express preemption which forbids Alaska from doing that, and there's no sort of conflict with federal law or the Constitution because Alaska can argue that they can do that under the 10th Amendment state powers rights, then there really isn't this issue of any sort of conflict. When we think about preemption, we think about conflict or we think about a field, and we usually analyze both. And so within preemption, as we talked about previously in our crash course, we talked about field preemption. Where field preemption, we've got a number of factors here. Our general rule here is that if federal law intends to occupy the field, then state law is preempted, even though it parallels with federal standards. So there might be an area of law in which there might not be a conflict between state law and federal law, but if the federal law intends for the federal government to occupy the field, then the state law is preempted. Other factors that we look at discrimination against state residents, for example. We might look to how pervasive is federal regulation, one or all aspects of the issue. And we look to the subject matter traditionally classified as local or federal. And we also look to how similar are the goals of state and federal law, and if there is a need for uniform regulation or issue within this aspect of field preemption. So there might not necessarily be a conflict, but if federal law intends to occupy the field, then state law is preempted, even though it might even fall in lines with the federal standards. So if the federal government decides to ban certain types of tobacco products, for example, and they do that through maybe through the Commerce Clause, through taxing and spending, through necessary and proper clause, and they argue that it's within their power, in that case there's this issue of field preemption, that even though states might decide to ban a more narrow set of products, like if the federal law creates a ceiling, or if they create, if they decide to ban all tobacco products or just a number of them, then maybe perhaps the state law will ban more and be actually over-inclusive in their ban on tobacco products. Then there is that issue of field preemption. Did federal law intend to occupy the whole field? Well, if the federal law decided to only regulate a subset of tobacco products and only ban, for example, electronics tobacco products, then or a specific company manufacturer, such as a chemical within an electronic tobacco product, and a state decides to fully outlaw all tobacco products, that's where we can talk about field preemption. Federal law intended to occupy the field, a narrow field, but then states decided to make that even broader in their ban. You might not necessarily have that issue of field preemption, and you want to argue whether or not there's a conflict. Maybe there is no inherent conflict, but there might be an issue with field preemption. Most likely not, depending on how you apply those facts. And so it makes for a good possible essay scenario. And also, related to this topic, we'll talk about the Dormant Commerce Clause, as we discussed in our last video. We touched on this topic. Within the Dormant Commerce Clause, we have when Congress has not acted. Usually, we've got within this paradigm, we always look first to our Privileges and Immunities Clause analysis. And so we'll look to whether our two-part tests, usually, our balancing tests related to this topic. We've got a balancing test in which there are two aspects to the Dormant Commerce Clause. As we talked about, discrimination against state residents, burden on state regulation or state regulation parts, or maybe perhaps we'll see how the DCC, the Dormant Commerce Clause, we'll call it DCC from now on for simplicity, operates on state law. And we'll look to burdens on interstate commerce. And within that first element of discrimination against state residents, I'll get a pen here so we can easily mark this, against discrimination against state residents here. We look to how the DCC operates on state laws that might burden interstate commerce. There's usually no federal regulation for the Dormant Commerce Clause. Usually this applies when Congress has not acted. And so we look for states, for example. If Congress has acted, then we look for preemption. But if Congress has not acted, then we can discuss more about the Dormant Commerce Clause. So that's how we can kind of bridge the issue between how a lot of times Congress and states might overlap in certain areas of lawmaking, where the states can actually have a more expanded role, and Congress might just set a minimum standard, and states can raise that standard. That is a good example on how we can think about these concepts. So within this principle, for the takeaway, the analytical framework here, we want to look to whether or not the regulation is national in subject matter, requiring some sort of uniform application across the states. If it interferes with interstate commerce, then more likely the state the state law is likely invalid, since we don't want those burdens on interstate commerce. That's how I like to think about Dormant Commerce Clause. It's like the antithesis of Commerce Clause, when states try to burden interstate commerce, whereas Congress really should try to let states on a more equitable, allow states to perform on an equitable playing field in which we won't have any burdens on interstate commerce, and we can treat Americans equally, whether if they live in Alaska or if they live in Tennessee. That's how we should look at these laws. We want to look whether or not if the regulation is national subject matter requiring uniform application. If it's not uniform, then more likely here we're going to have subject matter more geared towards local matters and which will require and allow for diversity and regulation, and which will more likely be upheld than not. And so state regulations only they'll pass if the issue is local in character or effect. So we'll look at the manner and the characteristic of the state law, and we'll also look at if there's impact on national commerce and whether or not it interferes with its operation. That's part of our overall analytical framework here. We talked a little bit about a balancing test here. So whether or not that's exclusive or if they're concurrent zones. So two zones from Cooley, where, as we talked about previously, the state and Congress might actually share some powers, Or it might be that the state or Congress have exclusive powers. So endless examples here. We talked about the two aspects. There's some sort of burden on state regulation, which the burden from the state regulation applies to interstate commerce, and also it creates discrimination against other state residents. Absent of no federal regulation for Dormant Commerce Clause, Congress has not acted. If Congress has acted, then we look for preemption. We talked about a little bit of our analytical framework and our balancing test. Within our takeaway analytical framework, it's also important here to look at whether or not this is national subject matter requiring uniform application, or if it's local, if it only applies to local issues and character or effect, and whether or not that impact on commerce is does not seriously interfere with its operation. We look at different tests that the court will use. We look at whether or not the state law is facially discriminatory, and if it targets in-state or out-of-state actors differently. And for example, state government has exclusive power to regulate, whereas states have concurrent power in those areas. And we look to whether or not if the state is facially restricted but gives incidental burden to interstate commerce, it's okay as long as it passes the test here, the balancing test, and does not help if the state is opposed to out-of-state residents. The consequence incentive to deal with the national mistreatment is slight. We'll look for a discriminatory effect. So within a discriminatory effect, we look to, even if the law treats in-state and out-of-states equally, if they're imposing same requirements, which might create some sort of discriminatory effect, negative impact on interstate commerce under that case Hunt. And so within this case, we look to whether or not there's a discriminatory effect, but we also look at whether or not the law is facially neutral. So is it facially discriminatory first? Then if it is facially discriminatory, then more likely the state law might actually be struck down if it discriminates against other out-of-state actors. But also we need a discriminatory effect where even if it does treat people unequally, we need to see some discriminatory effect, and that is our test. We look to facial discrimination, we look to the effect. We look to whether it's effect, and if it's facially neutral then, but it gives a discriminatory effect, then usually we'll apply the applicable level of scrutiny, and if it has a discriminatory purpose, then that's when we'll apply the strict scrutiny, for example. And if it's conserving resources for one state, Alaska, there's another issue with timber processing in Alaska. The same freedom started on the business, for example, market participation exception, where cannot be both regulator and participant in the market. It actually requires congressional consent and approval in that case for these exceptions that might apply, where Alaska might be competing on the private market, but Alaska shouldn't be able to regulate in order to discourage other businesses in competition. Same freedom, same standard as other businesses, for example. We also look to if there's an incidental burden on interstate commerce here if the state law is facially neutral, it's okay as long as it passes a balancing test and does not help in-state as opposed to out-of-state. And we look to that as a consequent incentive test in dealing with a national system. So again, first test that state law, if the state law is discriminatory, if it targets in-state or out-of-state actors differently, federal law has exclusive power to regulate, whereas states have concurrent power. Within our balancing tests, we remember that in Cooley there is, it can depend based on this test, where in this case the DCC, Dormant Commerce Clause, forbids states from legislating that, from any legislation that unduly burdens interstate commerce. We look at whether or not it's pure economic protectionism, and in that case, if it is, then it's an economic barrier. Cardozo and HP, in that case, the states have police powers to regulate matters of legitimate local concern. And there was that unique exception that we talked about. Well, there's a baitfish case where state statutes that affirmatively discriminate against interstate commerce passes strict scrutiny, where it attempts to protect or prohibit significant damages, like the environment, for example. If the burden is clearly excessive versus putative local benefit, then it violates the Commerce Clause. If the burden is only incidental, then it puts undue burden on interstate commerce. We look to whether or not legitimate economic state interests include conservation of energy, for example. We want to look for some legitimate purpose here, if there's a legitimate state interest within the court's test, and if where out of state is equally taxed but only in state, we get strict scrutiny for discrimination. We look to whether or not there's an affirmative burden, the state welfare is significantly in danger, or there's some sort of legitimate interest there. If the state law is actually deemed discriminatory, as we'll talk about, is actually deemed discriminatory and puts that undue burden on interstate commerce, then burden is only incidental. Burden is clearly excessive versus putative, then it violates the Commerce Clause. Legitimate economic interests include conservation of energy, as we discussed, natural resources, or some similar benefit, but non-legitimate is always per se invalid, regardless of the reasons, if there are less discriminatory means to accomplish the result because of strict scrutiny, and kind of relates to narrow tailoring. Explicit language puts intentional burden on interstate commerce. We look to facial discrimination, we look to facially neutral, we look to discriminatory effect, and we've got that exception for market participant exception, where where we need congressional consent or approval, and usually states cannot be both regulators and market participants. We have the same freedoms as other businesses. We look to unique exceptions that the court recognized, like protecting the environment and protecting from significant damages. And we look to that balance against the state police powers. So a lot of these concepts actually do overlap, and that is a great way to remember DCC and preemption, kind of thinking about them together. And so next we can talk about federal executive power. So the way I drew out my map is that it's kind of in borders. We've got here, this is cut out in orange. I don't know if you can see it here, orange. We talked about that part on our map. We talked about limits on state regulatory and taxing power, preemption, Dormant Commerce Clause, various different tests. We looked to discriminatory purpose, facial discrimination. We need discriminatory effect and whether that raises the applicable level of scrutiny, and whether or not it passes that compelling purpose. If it does, if there is some sort of justification, and some sort of exceptions that we talked about, like the exception of significant damages, preventing significant damages on the environment. We look to legitimate economic state interests versus non-legitimate interests. They don't necessarily have to be economic, but it helps to have some sort of legitimate interests there. Legitimate non-economic state interests, I mean, because economic interests might fall more along lines of the market exception that we talked about. State welfare significantly in damage, then affirmative burdens. Burden is only incidental. If burden is clearly, we look to whether or not the burden is incidental. And so that is our takeaway. That is a good high-level analysis for a DCC. So I'm gonna actually, so next we'll talk about here, the federal executive power. A lot to talk about here within the context of separation of powers. We talked about previously the non-delegation doctrine, where you cannot give unfettered discretion to legislate. That's Congress's ability. Article 1, bicameralism. You have the presentment clause, line item veto is unconstitutional, as we talked about in that Clinton case. We will discuss how to determine if an action, if a legislative action is constitutional or not. But Congress may not delegate legislative responsibilities to administrative agencies. We talked about that ban on delegation of their legislative powers to other agencies. Whether the action contains matter properly regarded as legislative or in character or effect. You want to ask if it's, yes, that's a question that you want to ask in your analysis in the essay, and analyze whether the action contains matter that's properly regarded as legislative or in character or effect. We want to discuss the nature of the decision. So we have to ask, does the action alter the legal rights, duties, and relations of persons? And then we also look to the separation of power structural analysis, as we touched upon in our last video. Justice Powell, in this famous case, the INS case, Chadha case, there are two ways separation of power may be violated. Structural, as referenced in Jackson, and we'll talk about justice. So there, the two ways in which separation of powers can be violated. First, whether the action is whether it impermissibly interferes with another branch's performance of its duties, and second, the aggrandizing, taking over, assuming the function of another branch of federal government. Is it impermissibly taking the other branch's performance duties, or if it's taking over, assuming the function of another branch of government? So is the judiciary making law as opposed to interpreting law? Is the executive making law as opposed to applying law? Or maybe perhaps if the legislative if Congress decides to overstep the president and execute the laws, we look for that. And if they're taking over the function or if they're interfering with another duty. So both related topics. Justice White's dissent, functional analysis. In his dissent, he talked about looking to instead of the intent of the framers, and the real question is whether legislative veto is consistent with articles, purpose, and separation of power principles to give the legislator oversight power because of practical reality. And so we'll also talk about here, this general rule that we have is that courts will uphold congressional intelligible principle, which is this broad power to delegate rulemaking to executive offices, administrative agencies. But to be delegable, power must not be uniquely confined to Congress, and included the intelligible principle for a delegate to follow in construction of their rules. And anything suffices for intelligible principle, upholding public interest, setting fair and equitable standards, for example. And there's this high deference to Congress there. And so we talked about all of this, looking to the intent, dissent. We'll also talk about, in this case, the president faithfully executes laws where within the context of the non-delegation doctrine. We already talked about this with in terms of Congress not being able to delegate their lawmaking duties. But we have this concept within the executive that's called the vesting clause, Article 2, where the executive power shall be vested in POTUS, in the President of the United States. And we look to several cases, such as Youngstown sheet, where Justice Jackson gave us the classic tripartite framework that we will use for our essays, where we need to look at, as we touched upon in our last video, but we'll say it again because it is important. The president acts in accord with express or implied authorization as a first category, and second, and they kind of go from order of highest power to lowest power for the president to actually be able to argue that this is within their authority. Congressional silence, or zone of twilight, otherwise known as acquiescence. And president's actions are incomparable with the express or implied will of Congress. That's the lowest tier. Really, if we're going to argue something that's within the second tier, that's kind of, it's in the zone of twilight where Congress is silent. You can argue other powers to make that justification in finding your conclusion. If it's the last where the president's actions are incomparable with the will of Congress as expressed or implied in the Constitution, then more likely the executive power will not be upheld. And this can also be remembered as a formula, where the formula is we take the power of the President of the United States and we subtract out Congress's power. And so if in this algebraic question, if the president's power outweighs Congress's power, then the president will win. But if Congress outweighs the federal government's power, then Congress more likely will win, and the president's law would be struck down or action. And remember just to look at the after analyzing the categories for either whether or not it's within their inherent power, if it's express or implied authorization, or if there's congressional acquiescence, or if there's some sort of incomparable with some sort of conflict with express or implied will of Congress, then we'll look to congressional acquiescence in a systematic and unbroken executive practice. So there, we talked about the intelligible principle, we talked about high deference to Congress, whether the action is impermissibly interfering with another branch of performance duties, or aggrandizing, taking over. Just remember to look for that congressional acquiescence and in some sort of unbroken executive practice where Congress might have known the president was acting a certain way and allowed it for so many years. That might help us if it's kind of in the middle, or if it could really go either ways in a fact pattern. And usually bar exams like giving us facts where they can go both ways, where cases are so close, they could really go both ways, and it depends on how the law is applied. So here, again, anything suffices for intelligible principle, upholding public interest, setting fair and equitable standards there. And that, in a nutshell, is that broad power to delegate rulemaking to executive officers, admin agencies. Power must not be uniquely confined to Congress and include the intelligible principle for a delegate to follow in construction of their rules. We talked about a lot of this. I think before we move on, we'll talk really quick about checking we'll move on below, checking the power of administrative agencies. Now this, we'll talk first about Article 2, the appointment power, and we talked about this in our last video, but again, principal officers, POTUS, President of the United States POTUS, nominates and the Senate consents ambassadors and other public ministers, consuls, judges of the Supreme Court, and officers of the United States. And so, very interesting time to study all this. It's the day before the special election in Georgia, as I'm recording, and also there, it can really go either ways, whether or not Congress and the Senate specifically will consent to the incoming president's cabinet or their other public ministers, or maybe perhaps any future vacancies in the court. And principal officers are distinguished from inferior officers, in which Congress may vest the appointment of such inferior officers as they think proper in the president alone, or to the courts of law or heads of departments. Checking power of administrative agencies, the scope of inherent power. We look to how the executive implied but not absolute privilege within U.S. versus Nixon. There is this implied privilege, but it's not absolute, such as in criminal cases. And so we also look to a balancing test here. If we have an issue with the president and any sort of alleged criminal conduct, we want to balance this first issue of the importance of general privilege of confidentiality of president's communications on, such as on military or diplomatic necessity, and the frequency of disclosure related to any sort of tempering candor, balance against the burden such a privilege might have on the fair and administration of criminal justice, such as whether or not it undercuts due process, gravely impairs basic function of the courts. We ask ourselves also within the scope of inherent power, whether or not if Congress vested that appointment power in the judiciary and removal authority in the Attorney General. So in that case, it did not usurp executive authority for itself, as it was vested in the judiciary and vested in the Attorney General. Within the appointments clause, ask yourself if in your fact pattern if it is in a principal or inferior member, and balance that against separation of powers. And remember that there is a limited tenure duration of office usually, that there's limited jurisdiction of that office, and a limited scope of duties of that office. And there's always a possibility of being removed by a separation of powers officer. And so, does the government action violate separation of powers? Is one of our questions. Is the officer's duty or duties executive in nature? And if we say yes to that question, then does the statute deprive the president of the exercise of purely executive power? And this leads us to our tests. And we said that we have a balancing test. We balance the importance of general privilege of confidentiality, such as in protecting military or diplomatic privacy, and what the frequency, balance against the burden such a privilege has on the fair administration of criminal justice, undercutting due process, gravely impairing basic functions of the courts. We've got a test here, the CLEAR test, which we talked about. And just in summary, in our tests, we want to look to whether the matter was so central to the function of the functioning of the executive branch as really to require complete control of whether executive retains sufficient control over matters to be decided, that is able to perform its congressional duties. Within there, we have this test, NRLB versus Canning, where POTUS may invoke a recess apportionment clause to fill a vacancy that exists during sufficiently long recess. 3 days was not viewed as being sufficiently long recess. Senate was still in session with capacity to conduct business and retained unanimous consent business to provide advice and consent of presidential nominees. So in that case, look to your fact patterns where we want to look for 3-day recess is not sufficiently long to the central functioning of the executive branch as to complete control of whether to require complete control of whether executives retain sufficient control over matters to be decided, that is able to perform its congressionally assigned duties. So there, if we have some sort of recess or vacancy, then the president, if it's sufficiently long, but 3 days is not so sufficiently long. If it's longer than that, then the president may invoke recess apportionment clause to fill a vacancy that exists during a sufficiently long recess. And I like to think about the Designated Survivor series. Very interesting show, very amusing. If there is such a scenario, how would we proceed in such a long recess that it would take for us to have elections again and fill vacancies? In that case, there might be a theory there in which the president could actually invoke that recess apportionment clause and fill a cabinet, for example, or fill seats. If the unthinkable happens, like in the series, then that's where we could talk about it, and it might be an issue. It might be a potential fact pattern. Again, when you think about these different concepts, it's always good to imagine different hypotheticals so that these concepts really stick. So we'll talk a little bit more on this chart. We talked about that first half. We talked a lot about federal executive power. We talked a lot about limits on state regulation, regulatory and taxing power. We'll talk about removal next. Removal is very useful as well. Removal is the general rule of removal is that in general the president has the power to remove executive officers because the removal power is part of the apportionment power, as we talked about. Removal is incident of the power to appoint, to make those appointments. It's incident to that. There are different separation of power approaches. There is the checks on the president to state and private conduct. We look for congressional acquiescence usually. And the general rule that we have is that if the president has absolute immunity from all civil suits for actions while in office, but that's distinguished from criminal. Makes for a really good multiple choice question. I'm sure it'll pop up. I'm sure it pops up in your practice questions. Applies application of BOR to states. There's a standard for incorporation. Fundamental to the scheme of American justice is our first question. If sacrifice, no liberty, if fundamental rights are sacrificed to no liberty, then or equality, then we want to look to fair trial, for example. We want to look to different rights in our analysis. Are they so rooted in the tradition and conscience of our power? Are they fundamental rights? They must be protected, then yes. Then applying BOR to private conduct, applying a lot of this to private conduct, we want to look at here. Congress in most cases the Constitution in most cases, only apply to government and not private actors. So in your essay, you want to talk about whether or not this is a state actor or a private actor, because remember, these constitutional protections, as we'll talk about in our next video, apply to state actors and not to private actors. The 13th Amendment ended slavery. Let's see here. There's a state action doctrine. There's a legal precision element of how we take the BOR and push that through the 14th Amendment. Bill of Rights, yes, BOR, sorry, I should have said that earlier. Application of the Bill of Rights to states that the Bill of Rights and our protections, like when it comes to protections on free speech, we'll talk about in the next video, that does apply to states. We'll talk about reverse incorporation. It's pushed through the Due Process Clause, provision as applied to the states through Due Process Clause with amendment. And next we'll talk about the State Action Doctrine over here, State Action Doctrine. So there, within the State Action Doctrine, the state action generally is, fact-bound policy there. And we look to principles of fairness, and our underlying question is whether or not the state sufficiently is implicating the challenged activity to warrant application of 14th Amendment. Within the State Action Doctrine, there is this issue of mere state holds a public actor to liability of, let's see here, there's a joint party of reliance, some sort of mutual benefit. We look at whether or not there's the entanglement exception here. If the 14th Amendment includes both of Bill of Rights provision, it applies only to government action. But there are different exceptions here. There's a public function exemption in which we could actually hold private actors to the Constitution, in which here we look to whether a private actor performing state action or state public function exclusively and traditionally has been traditionally performed by government. So it might be like a military contractor or maybe some sort of vendor contracted to oversee online distance learning during COVID. There is the entwinement theory or the hybrid theory. I like to remember this as a hybrid theory. There's a state action which may be found if there's such a close nexus between the state and the challenge action that seemingly private behavior may be treated as that of the state itself. Other exceptions are the authorization exception. There's a test that we get, the general Blum test. We look to whether or not the person is a state actor. We look to this test of state-created situation of delegating those constitutional rights or assignment, in which within our test we look to an active encouragement enforced against private actors. We looked at some sort of, if government provided state actors significant encouragement, such as a restaurant and government building, but mere state license, to hold public auto manufacturers to liability of states, there's a joint performance or reliance, then it might actually apply to government actors if there's some sort of mutual benefit, commingled participation, entanglement, or if perhaps this relates to the state exercise of power. And we want to look at significant encouragement from the government, and we want to focus on the state's intent there. So those are examples in which we might have a private actor actually being held to the Constitution. We talked about the standard for incorporation of the Bill of Rights to states, whether they're fundamental to the scheme of American justice. You can talk about this in a number of ways. I've seen it before on essays where you can say that it applies to the states through reverse incorporation, talk about 5th and 14th Amendment very generally, about the Due Process Clause. There are also, here, we'll talk really quickly, limits on congressional power before we move on to this section of our map. Limits on congressional power. Congress can limit the president or presidential removal to instances where good cause is shown. Congress cannot cannot completely prohibit someone from being removed. Congress cannot put more than one layer of good cause restrictions on president's removal power. Congress cannot give the removal power to itself, and other than by exercising the impeachment power. So they can't really give the removal power to itself. They can only put one layer of good cause. They can't completely prohibit removal, but they can put one layer of good cause, and they can limit presidential removal to instances where good cause is shown. They can do that. And so Congress may limit the president's removal power if it is an inferior officer, or office where independence would be desirable. And congressional power, there are limits on presidential power. There's impeachment. There's ultimate check on president, which is impeachment. And Article 2, removal for treason, bribery, or other high crimes and misdemeanors, whatever the majority of the House thinks also. So it has to be some sort of serious threat to society. And so we have here, we talked about applying the Bill of Rights to states' fundamental scheme of American justice rooted in tradition. We'll talk in our last section of this video, we talked about removal. Other separation of powers approaches. There's this formal strict separation of powers under Brauscher, where any intrusion, no matter how small or technical, by one branch into the constitutionally assigned power of another branch violates separation of powers. No active role for Congress to supervise officers charged with execution of law. And we look to the functional pragmatic separation of powers under Morrison, where the court is concerned whether there is a genuine threat of encroachment, aggrandizement of one branch at the expense of another. Real question is whether removal rests of such nature impede president's ability to perform his constitutional duty. We distinguish foreign and domestic police powers, as we touched upon in our last video, where the president has inherent foreign affairs power because foreign affairs and domestic powers are fundamentally different. General rule here is executive power stems from either Constitution or an act of Congress. Then apply our third category of Jackson, as we talked about, the tripartite framework, where we will look at balancing the president's power versus Congress to see which one wins. And here we also have this can always be repealed, amended, superseded, where the Constitution, we look to Constitution, treaties, federal statutes, executive agreements with foreign entities, and the state law, and the hierarchy there, where Congress, again, cannot limit presidential power under Article 2, but there's a Roberts dissent, which is interesting. Must disable. It depends here, so we'll actually ignore that piece. And lastly, we'll talk briefly about 14th Amendment challenges, since this is an important analysis. May come up, it's a great essay, or it could be a multiple choice question. Here we look to, within our 14th Amendment challenges, economic substantive due process. Issue is the law is being challenged as a violation of the 14th Amendment due process clause. 14th Amendment is triggered when a law limits made by a state or a state actor the activity for persons to engage. 14th Amendment requires both here, requires a procedural due process, some sort of, within procedural due process, we think about fairness, traditional notions of justice, we'll talk about in civil procedure actually. We look to whether or not it deserves, if it has some sort of deprivation of life, liberty, or property. Traditional notions of justice, which are so fundamental to the scheme of American justice. Many different types of words you can use there. It requires that procedural, but it also requires substantive due process. And the focus here, procedural due process and issues with notice and fairness, that kind of relates more to civil procedure, as we'll talk about. Here, we're more worried about substantive due process for the purpose of constitutional law. And there, the question is whether the government has an adequate substantive reason for depriving an individual of their rights for liberty, life, and property, such as throwing someone in jail, or prohibiting someone from following their economic potential, or maybe restricting abortion or restricting marriage. We'll look to those fundamental rights. Deprivation of economic liberty, though, this applies the rational basis test. You don't have a fundamental right to do whatever you want economically, unfortunately, or not unfortunately. You can't just destroy a forest just so you can get money, or go to a national park and drill. Congress, the federal government has authority to set regulations there. Within deprivation of economic liberty, such as preventing children from working because of child labor laws, is there a legitimate interest here, is our first question, because that is a rational basis review test for usually economic issues. Is there a legitimate interest, and is that regulation rationally related to protect that public interest? And that is usually a very low bar. Only a few scenarios that we'll talk about in our next video, most likely, where the courts have actually ruled that rational basis test was failed by the state actor. So courts no longer hold freedom of contract as liberty under due process clause. They used to, as we saw in some of our child labor cases. Rational basis, remember that we are looking for a legitimate interest, reasonably related or rationally related to public interests, and we look to, within strict scrutiny, the highest level of scrutiny, before we delve into this concept of intermediate scrutiny and some applications of our next topic. For strict scrutiny, we need a compelling interest. And in order to achieve that compelling interest, the means that the government chooses is necessary to achieve that public interest. So we look to the means and we look to the result as both parts of our test regarding whether we're using rational basis or strict scrutiny. The result being that legitimate interest for rational basis and compelling interest for strict scrutiny, and the means being reasonably or rationally related under rational basis, and necessary or narrowly tailored, as we'll see in strict scrutiny and intermediate scrutiny. And you can argue which one should apply based on case law, based on your facts, and based on your framework of analysis. So remember here that we talked about fundamental rights, we talked about here, remember that the general rule is that a law that places an undue burden on a woman's liberty interests in the abortion decision is invalid, the unburdened abortion cases. Here, in our analysis of fundamental rights, just generally, we look to identification of government actor and to see whether the 5th Amendment or 14th Amendment apply. We assert rights as fundamental rights. We look to regulations designed to foster the health of a woman seeking an abortion in abortion cases, which are valid if they do not constitute an undue burden. And we apply tradition. We look to focus on deeply rooted rights in our history as a nation and tradition. And we can apply to the dignity alternative paradigm, the focus on if the right is central to human dignity. And so and then we look to whether or not that constitutional right is infringed in our analysis. And is there a direct and substantial interference with that right? So in the case of undue burden tests, we look to an exception for abortion where the means are necessary to achieve a compelling government interest, and apply strict scrutiny, violated if government conduct does not pass that test, or fundamental rights, where we have privacy as a fundamental right under substantive due process through the word liberty and due process in the due process clause. And I like to remember a lot of these rights, other than abortion, as we talked about, and the undue burden test, which we'll discuss last in this video. I like to remember this with the mnemonic that I got from a friend. It's a very popular one. It's Mary. Or actually, I twisted this. I didn't like I forget how they said it, but I remembered it as Mary keeps contraceptives at parents' penthouse, or you can say plaza. Mary keeps contraception at parents' penthouse. Now, these fundamental rights, each first letter of that sentence corresponds to the fundamental right. So Mary meaning marriage, keeps meaning keeping the family, contraceptives meaning, of course, contraception, keeps at for abortion, of course, parents for right to parent, penthouse for procreation. So procreation, contraception, keeping the family, parenting, abortion, marriage, they're all usually interpreted as fundamental rights, and most likely, and will be interpreted as fundamental rights based on current case law. And so there, within the undue burden test, however, in the context of abortion, this comes up again where we have time restrictions on abortion that state laws have attempted to pass, which restrict the right for a woman to choose whether to terminate her pregnancy based on time restrictions. However, that they may be upheld depending on the jurisprudence that you apply and the analysis. So regulations designed to express profound respect for life of the unborn are permitted if they are not a substantial obstruction to right to choose. So for example, having an exception where at 9 months, where any day delivery can be made, that could probably be restricted because it's not a substantial obstruction depending on the jurisprudence. And in that case, it doesn't obstruct the right to choose because there was that 9 months to decide. Most time, it can abortions, I believe, happen within the first trimester, and they can happen through medical abortion, for example. I'm not trying to argue one side or the other, or to apply my personal political beliefs here. I just want to tell you that you have to argue both sides, and your conclusion doesn't really matter as much as the analysis that you choose in law, which is great. So yeah, we want to respect all opinions and viewpoints, and not silence those whom you might disagree with. And so we want to evaluate if there's sufficient justification or purpose within strict scrutiny, or whether or not rational basis test applies. Most likely, if it's a fundamental right, we'll apply strict scrutiny, and we'll evaluate the means if it is a method of sufficiency that relates to the purpose of the regulation or the interference with the right. And remember that the words here are necessary and compelling for strict scrutiny. And here, remember that within the undue burden test, which creates pre and post liability rules, that law that places an undue burden on a woman's liberty interest in the abortion decision is usually invalid, but we've got to see whether or not it is an undue burden if it actually does substantially obstruct that right to choose. Undue burden there, the state interest becomes more compelling there with viability versus pre-viability of. So in the earlier semesters, or earlier trimester, first few weeks of pregnancy, it might be more likely for a woman to exercise that fundamental right versus later on where there's viability of the fetus. And state interest becomes more compelling there with viability, in which post-viability the government may prohibit unless necessary to protect the woman's health. So in that case, if it's having to choose between two lives, then the state may prohibit, may not prohibit the abortion if it means saving the woman's life. And government may not prohibit abortions, but may regulate if there is no undue burden on ability to obtain an abortion. And Justice Blackmun offered a famous dissent where strict scrutiny should not be abandoned because this looked like its own level of scrutiny, whereas we talked about rational basis review for that legitimate interest that's reasonably related to a public interest or to the means, or versus strict scrutiny to compelling interest that's necessary to achieve, necessary as to the means and compelling interest as to the purpose. It seems as if in a lot of these abortion cases on time restrictions that the courts are applying their own standard of scrutiny with the undue burden test, that so long as there isn't an undue burden, so long as that right, that fundamental right is not is substantially obstruction, and it's in all caps here because that is our rule here. Extra points if you can name that on a bar essay. If you name substantial interest there, or substantial obstruction to right to choose, then you're likely to get more points, and the graders should notice that. And so there, evaluate the sufficient justification purpose. This undue burden test usually applies to the concept of abortion, but we apply a lot of these, a lot of what we learn through marriage, abortion, parents, procreation, contraception, keeping the family, to maybe perhaps other fundamental rights, as this is not this doesn't capture the full scope of fundamental rights, of course. They're just traditional notions of fundamental rights. And who knows, as technology and society changes, we might have to update our jurisprudence or apply parallel reasoning from these fundamental rights to other fundamental rights, such as maybe data privacy on the internet, since a lot of these cases were determined before artificial intelligence and before our data became mined, and before our data no longer became our full private data, but was kind of aggregated in different internet companies. A lot of different applications. We might think about this in the concept of changing technology, which we might see long after we're gone. So we'll see, but we'll see how these either expand the notion of applicable levels of scrutiny and how they evolve with technology. This is why constitutional law, as you can tell, is one of my favorite classes, because you really see the formation of our country based on the single Bill of Rights and our Declaration of Independence to really the Constitution exploding into various case law, because we're not a statutory country, we're based on common law. So we look at cases over time to make our assessment, to get our analytical framework, and sometimes the Supreme Court might come back and change a lot of their jurisprudence, and that's why it's always good to look backwards and understand the history of changes over time, because law is fluid, law changes, but we always have hope that our Constitution and the textual, the express words of the Constitution will always hold true, such as the Due Process Clause, and such as fundamental rights and restrictions on whether or not the government can infringe on free speech, as we'll talk about. And so I love constitutional law because I love our country, and I believe that with constitutional law, if you understand constitutional law very well, it's easier to understand criminal procedure, since that seems like it's its own constitutional law case, looking not at the 14th Amendment, well, kind of, but more so looking at, actually, yes, looking at the Fifth Amendment for Miranda rights. But that's its own issue. Within criminal procedure, we look at the Fourth, Fifth, and Sixth Amendments, different rights to an attorney, rights to privacy. We look to rights against search and seizure without a warrant, or exigent circumstances, or probable cause. And so I love constitutional law because it also applies to criminal procedure and our rights in criminal procedure, our rights to free speech, our fundamental rights, but also just understanding how our government works, and when there might be conflicts between a divided government, which I think we might have to get used to in the future, because unfortunately we do live in a divided nation, and hopefully it will get better and we can see past our differences and appreciate the beauty of what our country offers through the Constitution. So thank you for watching this video. We'll cover our last charts in the next segment.